The term generative artificial intelligence, also known as generative AI or Gen AI, is used to describe any kind of artificial intelligence system which employs machine learning and deep learning techniques in order to create, according to the specific requests of the user, various types of media content such as text, pictures, audio tracks, videos. As such, generative AI is capable of creating something new, for example, a news article, after receiving human instruction, for example, a simple textual input asking for an article about a specific argument. The instructions given to AI systems are called prompts. In recent years, there has been a rapid development of new generative AI technologies and systems. For example, regarding textual contents, among the most famous systems, we all witnessed what ChatGPT is capable of. A similar phenomenon has been observed in the domain of figurative arts. Creative tools that are based on artificial intelligence, such as Midjourney, have emerged as a means of generating a wide variety of images from a simple human input. These tools are becoming increasingly prevalent. In this particular instance, the AI algorithm that forms the foundation of the tools processes the request and, through an autonomous creative process, generates an image that is consistent with the user's instructions. The widespread use of Gen AI solutions requires particular attention regarding the contractualization for related products or services, even more so when the output of artificial intelligence is used for commercial purposes. For example, when intelligent technologies are used to support creative processes in professional or business activities. These solutions can create outputs that, although theoretically worthy of legal protection under copyright law, sometimes lack the degree of originality necessary for a work to be deemed as copyrightable. It is no coincidence that the terms of service of the most well-known and widely used Gen AI solutions contain specific disclaimers regarding the possibility, which is far from remote or residual, of similarity of output. In essence, when the system has to process similar prompts and inputs, it could provide different users with similar, if not identical, responses. In the future, new regulations may be introduced to address the gaps in intellectual property rights created by the development and the use of intelligence technologies. These regulations will likely require that works must be created with significant human input to be eligible for copyright protection. Essentially, the usage of more or less advanced technologies such as Gen AI in order to produce creative works of intellectual property on which exclusive economic exploitation rights may arise will certainly not be prohibited, but in order for such products to be effectively protected by copyright, it is likely that the human contribution will have to be truly creative, demonstrable, and predominant compared to the machine contribution. However, in the absence of specific regulatory guidelines in this regard as of right now, it is strongly recommended to always review and validate any output via human control. This is to ensure the predominance of human input and to avoid the risk of similarity with other outputs similarly generated by other users. This is particularly important to avoid any risk of dispute regarding the use of any AI-generated output, such as complaints from another user who has exploited the same work for economic gain. Human control, supervision, and validation are also necessary to ensure the accuracy and the reliability of AI-generated output. In fact, it is well known that artificial intelligence could experience hallucination, i.e., objective errors of assessment or judgment. This aspect is clearly highlighted in the terms of service of most GenAI solutions, which include explicit disclaimers regarding the reliability, accuracy, and truthfulness of the outputs generated by intelligent solutions. Almost all GenAI services providers openly acknowledge that due to the probabilistic nature of intelligent systems, the results produced by machines may not accurately represent real people, places, or events. Another aspect that requires particular attention when using generative artificial intelligence technologies concerns system training. AI requires huge amounts of data and information to learn, improve its performance, and thus become increasingly reliable and intelligent. However, system training can pose risks in two distinct situations. On the one hand, data used for training purposes, which often comes from public sources such as the web, may refer to material covered by copyright, such as images, musical works, photographs, literary works. On the other hand, providers of generative artificial intelligence services and solutions very often reserve the right in their terms of service to reuse for system training purposes both the data and information entered into the system by the user as well as the results obtained in response to queries made to the system. In the first case, there could be an issue of infringement of intellectual property rights held by legitimate third parties over the works used for training the systems, whenever the system provider has not obtained the right to use those works legitimately. The hypothesis is far from remote. The courts have already been seized of the matter, and the first legal disputes have already been initiated for unauthorized training of GenAI solutions based on indiscriminate scraping of text or images freely accessible on the web, but nevertheless protected by copyright. For users of GenAI systems, the use of copyright-protected works as training sets for intelligent systems could become an issue if the copyright holder were to take legal action to protect their rights directly against the user. For example, by prohibiting them from using certain outputs obtained from the system or by claiming damages. In this case, the user has very little protection other than contractual guarantees. In particular, when assessing the terms of service of the GenAI solution, it will be advisable to evaluate the guarantees offered by the provider in terms of full availability of rights to the solution offered, the quality of the data used for training purposes, and the compensation and indemnification granted to the user in the event that the latter receives a claim by a third party. Regarding the possibility that the data entered and obtained may be reused by the solution for training the system and the algorithms, reuse that it is often clearly permitted in the TNCs, which often no one bothers to read, it is clear that this could be extremely problematic if the user has specific confidentiality needs regarding sensitive information or is interested in protecting their competitive advantage and therefore their know-how and trade secrets. Even in this case, it would be necessary to try to contractually guarantee a prohibition on the reuse of user data, perhaps by contracting with the provider for business version of AI products, which often offer greater guarantees in terms of confidentiality than free or consumer versions. In a context where current regulations often fail to provide answers to questions arising from new technologies or allow for a clean resolution of intellectual property disputes, a careful assessment of the terms and conditions governing the service and the protections offered or excluded by the provider is crucial. In summary, to best protect your intellectual property rights during the contractualization phase, the following points must be carefully considered within the service agreement as a baseline. Clauses defining what is meant by input data and output data. Clauses defining ownership of any content, both input and output, processed by the system, and setting out the rights to exploit such content, including any exclusive rights that the provider or user may exercise. Clauses clarifying whether the service or the solution provider may use the information put into the system and for what purposes. The presence of appropriate indemnity clauses on the part of the supplier in the event that the solution infringes the IP rights of third parties. Clauses governing confidentiality obligations, indicated their duration and specifying the technical measures adopted to guarantee the confidentiality of information owned by the user. Guarantees or exclusion or guarantees regarding the reliability and accuracy of the solution, to be assessed also on the basis of the use that each organization will make of it within its internal processes. In conclusion, we cannot help but to point out how many of the questions regarding the relationship between AI and copyright open up unexplored scenarios, both for legal and regulatory field. For this reason, we must proceed with caution and, where possible, resort to contractual agreements that clarify the rights and obligations of all parties involved in generating works through AI systems. We must also adopt specific best practice for using Gen AI technologies. It is especially important to make sure that you do not use any content protected by intellectual property rights when writing prompts unless you have the right to use that content. Always check that the outputs used do not contain any copyright protected content unless you are entitled to use such content. Always ensure that you have the necessary permissions before using certain prompts and outputs. Always review the outputs generated by the system to ensure their accuracy and reliability, and to guarantee the predominance of human input, which is necessary for the output to be protected under copyright law.